Hey everyone and welcome. I am absolutely thrilled to have you here for this explainer. Today, we're diving into a really fascinating and honestly absolutely crucial legal concept. We're looking at that delicate, sometimes super blurry line between an everyday promise and a strict, court-enforceable contract. I mean, we all make promises, right? We promise to grab lunch, we promise to do the dishes, businesses promise to deliver goods. But when exactly does the law step in and say, hold on, you have to keep that promise or you're going to pay the price? Well, it all comes down to a legal doctrine called the intention to create legal relations.
Okay, so here's our agenda for today. We'll kick things off with the promise versus the contract, then move into domestic and social agreements, along with their exceptions. After that, we'll cover business and commercial agreements, the exceptions there, and finally wrap it up with our final verdict on legal intent. Let's get into it.
Section 1. The promise versus the contract.
So intention to create legal relations, it's basically the legal doctrine that determines whether parties to an agreement actually intended for it to be enforced by a court of law. You can have a clear offer, you can even have an acceptance, but without this specific objective intention that the whole thing is legally binding, your agreement is really nothing more than a simple promise. The law isn't out there trying to police every single interaction we have. It's looking for that serious, tangible legal intent.
Section 2. Domestic and social agreements.
To really get this, our journey actually starts way back in 1605 with the case called Weeks v. Tybald. Picture this. A father is boasting, bragging really, that he'll give £100 to any suitor who can successfully woo his daughter. Naturally, a suitor steps up, does the wooing, and then asks for the cash. But the court's verdict? No way. Not binding. The court decided it was completely unreasonable to enforce general boastful words spoken merely to, quote, excite suitors. The big takeaway here is that statements not seriously meant, even if they sound incredibly enticing financially, just don't create a contract.
Flash forward a bit, and the modern rule was just beautifully framed by Lord Justice Atkin in Balfour v. Balfour. In this one, a husband who was working abroad promised to pay his wife £30 a month. Eventually, he stopped paying, so she sued him, but the court actually said no. Lord Atkins stated that in domestic arrangements, the real consideration is natural love and affection, which counts for so little in these cold courts. It's a great quote. The overarching theme is that the law tries to act like an objective, pragmatic bystander. It wants to maintain order, for sure, but it actively tries to avoid policing our dinner tables. The baseline presumption is that spouses, parents, and kids don't intend to drag each other to court over everyday household stuff.
We see this exact same presumption pop up again in Jones v. Padavatin. So here, a mother agreed to financially maintain her daughter if she studied for the bar exam, and she even went as far as providing a house for her to live in. Sounds serious, right? Well, later on, they had a pretty bad falling out, and the mother wanted her house back. The daughter tried to claim they had a binding contract. But the result? No contract. The court viewed the whole thing as a very informal family arrangement because it was heavily based on family ties and affection and literally had zero formal legal documentation. There was simply no intent to create a binding legal contract.
But let me pose a question to you. What actually happens when family members stop acting like family and, well, start acting a bit more like strangers? Or what if substantial amounts of real money and property are explicitly put on the line? Does that general rule still hold up?
Section 3. Exceptions in social agreements.
Normally, as we saw in Balfour, spouses who are living happily together, living in amity, don't create legal relations. But the big exception here is separation. Look at Merritt v. Merritt. Mr. and Mrs. Merritt were in the process of separating. Mr. Merritt promised, in writing, to transfer the house to Mrs. Merritt if she paid off the rest of the mortgage. She did exactly that, but then he straight up refused to transfer the property. The court held that because they were separating, that whole presumption against legal relations, it completely vanished. When a relationship breaks down and you're negotiating property, you are basically bargaining like strangers, and the courts absolutely will enforce those agreements.
Another really major exception is when a social agreement has severe, life-altering consequences. In Parker v. Clark, an elderly couple convinced their niece and her husband to sell their own house and move in with them, promising them a share of their estate in return. When the niece was later kicked out, the court said, hold on, that agreement is binding. I mean, you don't just sell your home on a casual whim. That level of extreme reliance proves serious legal intent. It's the same deal in Tanner v. Tanner. An unmarried woman moved out of her rent-controlled flat because she was relying on a promise of a house for her and her kids. The court gave that promise real contractual force precisely because she had so drastically altered her life based on it.
And then, oh man, we have this stranger exception in Simpkins v. Pays, which perfectly proves that money can absolutely ruin family game night.
A grandmother, her granddaughter, and their paying lodger entered a weekly newspaper competition together. They shared the entry costs every week, and eventually they won £750, which was paid out in the grandmother's name. When she refused to split it, the court stepped right in. Why? Because the presence of the lodger, an outsider to that core family unit, completely rebutted the presumption that it was just a casual family game. It was deemed a joint enterprise, and that money legally had to be split.
So we've seen how family agreements work, and we know where those domestic exceptions lie. But do these exact same rules apply to businesses and corporations? Like, if two huge companies shake hands, does the court just assume they're being friendly?
Section 4. Business and Commercial Agreements. The answer is a resounding no, and the corporate presumption is perfectly highlighted in Edwards v. Skyways. Here, an airline was laying off pilots and promised them an ex gratia, which basically means voluntary payment if they agreed to leave. A pilot took the deal, but then the airline tried to back out. They claimed it was just a moral promise, not a legal contract, specifically leaning on their use of the words ex gratia. Well, the court strongly disagreed. In a business context, the overwhelming presumption is that parties absolutely do intend to create legal relations. You can't just slap the word voluntary on a payment promise in a formal corporate meeting and expect it to let your business off the hook.
Section 5. Exceptions in Commercial Agreements.
Now let's look at the flip side, how businesses can legally shake hands without getting tied down in a lawsuit. The most direct way is by using what's called an honor clause. Check out this incredibly striking one from Rose and Frank Co. v. Crompton Bros. Limited. It literally says, and I quote, "This arrangement is not entered into as a formal or legal agreement and shall not be subject to legal jurisdiction in the law courts." It's wild, right? If businesses explicitly, clearly write out that they do not want the courts involved, the courts will generally respect that. The whole thing becomes an agreement based purely on mutual honor and trust rather than legal force.
Another totally fascinating exception involves something called a letter of comfort. In Kleinward Benson v. Malaysia Mining Corp., a bank asked a parent company to legally guarantee a loan for its subsidiary. The parent company refused to give a hard legal guarantee, but they did provide a letter of comfort, stating it was their current policy to ensure their subsidiary could meet its liabilities, while the subsidiary went bankrupt and the bank sued. But the court held that a statement of present policy is really just a statement of fact. It is not a contractual promise about future conduct. It offered comfort, sure, but it had absolutely no legal teeth.
And then there are free gifts and promotions, which is a really fun area. In the Esso Petroleum case, Esso offered a free commemorative World Cup coin to anyone who bought 4 gallons of petrol. The tax authorities actually swooped in and wanted to tax these coins as goods sold under a contract. So the big question became, does a promotional free giveaway automatically create a legally binding contract with every single customer pulling up to the pump?
The House of Lords was actually deeply divided on this issue. But Lord Denning, in his super famous minority judgment, argued no. He said, quote, "It does not seem to me necessarily to follow or to be inferred that there was an intention on their parts that their dealers should enter into legally binding contracts with regard to the coins." Basically, his perspective was that just because a huge business is promoting itself with millions of free little trinkets, it doesn't mean they actually intend to create a strict, legally enforceable contract over a coin that's worth literally pennies.
Section 6. Final verdict on legal intent.
All right, so what's the big takeaway from this explainer? It's that context is absolutely everything in contract law. The law is always playing the role of the objective bystander. It looks closely at the setting. Are we dealing with family or is this business? It looks at the language. Were you just joking around or did you draft an explicit honor clause? And it looks at actions. Did someone literally sell their house based on what you said? So the next time you make a promise, especially one with potentially massive consequences, ask yourself, would that objective bystander see a casual favor or a legally binding contract? Figuring that out early is a question that could save you a ton of time, a lot of money, and maybe even a trip to those cold courts. Thank you so much for joining me on this explainer. I hope this really sparked your curiosity, and as always, keep learning.